Welcome to Probate Law from A to Z. Hi, I'm Attorney Dan Scott. I help families work through the probate process in a stress-free environment to provide certainty and closure when they've lost a loved one. We're walking through the probate process from A to Z. We're not doing all of the letters today. We're just doing the letter B. So today we're going to talk about the letter B, bonds. You know, when you file a petition to get yourself appointed the personal representative of an estate, one of the first questions is, will you have to post a bond? A bond is designed to ensure, that you perform your responsibilities as the personal representative. For example, it means that the insurance company that's writing the bond, there's that letter B again, the insurance company is guaranteeing if you run off with the money, they're going to stand behind you. Now, most of my clients say, well, Dan, that's crazy. I'll never run off with the money. I know that, and you know that, but the court doesn't know it, and guess what? The bonding company doesn't know it either. And so the insurance company charges you money for this bond. And basically what they do is they stand behind you and say, look, if you run off with the assets of this estate, if you steal the money from the estate, if you don't do what you're supposed to do in the estate, they'll stand behind it. Just like having a mortgage on your house. You know, if you don't pay the mortgage on your house is pledged as collateral for your payment of the mortgage. Well, the bond in a probate case says that the insurance company will stand as collateral for your obligation to perform in the probate case. Now, really, one thing that you can do when you do a will, that'll be when we get to the letter W. That's going to be a long way down the road here. When we get to the letter W, we'll talk about your will. But when you do a will, in most of the wills that we do, we say that bond is waived. And the reason why is because usually we've got family members handling the estate. And we don't think that family members are going to steal from the estate. And we don't want to add additional costs to the estate, which a bond does, because somebody's got to pay for that bond. And it's an expense of the administration of the estate. And so that's one of the reasons why maybe you want to do a will, which we'll talk about when we get to the W in the A to Z. You would have to do a bond if you don't have a will. If you are seeking the appointment as a personal representative of an estate where there is no will, that is when the estate is intestate, then the court's going to require you to post a bond. There's almost no courts that say you don't have to post a bond whenever you're a personal representative on an intestate estate, and certainly none in East Tennessee, which is where I practice. Okay? Hope that was helpful for you. We did the B's today. The next one, we'll do C's in the A to Z on probate law. Thanks for watching. Thanks for watching our probate law from A to Z. If you found this information helpful, would you go ahead and subscribe to our channel? On YouTube, hit the bell, jam it, because I want to be able to send you notices when we do new videos.